Hello guys, welcome once again to Think Tank TV. Now there's one thing I realized, that as much as we are all questing to climb through the ladder of life and become influential, to become a public person, we must also be ready to face the consequences that would come with being a public figure. Yes, a video has gone viral on the internet of the pastor of Omega Power Ministry in person of Apostle Sowore, who was caught live on camera having fun with over 6 girls in China. I'm going to be reserving my word because I want you to see the video for yourself. Before I do that, I'd like us to jump right into Rivers State to see a constitutional lawyer who has disintegrated the nitty-gritties surrounding the judgment that was given by Justice Joyce Abdul-Malik in the Abuja High Court.
I'll just go straight in. I mean, one of the things that Godfrey in that report had said was that the judge, Justice Abdul-Malik, in her ruling had said that the governor hadn't put proper things in place before spending allocations, hence part of our reasons for that decision. We've had this conversation since the debacle in the Rivers State House of Assembly with the defection of some of the members of the House, majority of the members of the House, and then only 4 remaining, the vacation of seats, the presentation of the budget, the illegality or legality of it. And I'd like you to just break it down for us because that's part of the crux of the issue. That the budget wasn't properly passed. It was only passed by 4 members of the House. That debate still exists. To set the foundation for this conversation, can you, from a legal point of view, give us your take on this? Was that an illegal, unconstitutional move by the governor to pass or to present the budget to only 4 members of the House, and it passed by only 4 of them and is operating since then?
Thank you very much and good morning, Nigerians. To have a proper understanding of what is going on is to also understand that what has happened in the Rivers State House of Assembly was never within the contemplation of the framers of our Constitution. For 20 members of a State House of Assembly to lose their seat by virtue of their decamping from the political party that sponsored their election without there being a schism, a division in that party. I don't think it was within the contemplation of the framers of our Constitution. And so we are, but of course, the framers of the Constitution had within contemplation that it was possible for a member to leave his political party without there being a division. Also, it is also possible to leave because there's a division, a schism in the political party that sponsored. They have made provisions for this. And because each member of the House of Assembly must be treated as individual members, the fact that 24 of them decamped, which I say might not have been within the contemplation of the framers of our Constitution, does not mean that the framers of the Constitution did not have in contemplation the fact that an individual member could decamp without there being a schism. I made ample provisions for this, that if a member of the House of Assembly decamped without there being a division within his party, and that division, of course, must be at the national level, it's not a question of the state. This has been decided in a plethora of cases already. It's settled. And therefore, the 24 members who decamped, it has been argued, had lost their seats by operation of the Constitution. Now, that matter has not been settled. The recent decision of the Court of Appeal has been also appealed to the ultimate court, the Supreme Court. And therefore, until we get a pronouncement from the Supreme Court, it is still not a point that has been settled. And that is why people have argued that the Federal High Court sitting in Abuja yesterday ought to have paused whatever it was doing to await the outcome of that decision from the Supreme Court as to the legality or otherwise of the decamping of these people and the placement of the budget by Governor Sim Fubara before the 4 members who people have argued are the only cognizable members of the House of Assembly as at today. But of course, there is a decision of the court. And for me, that is what is important. The law is what is. It's not what ought to be, if you may wish to argue. It is a pronouncement of the court that is the law. And therefore, the decision yesterday from the Federal High Court is the decision, is the position of the law as at today. However, is that decision final? No, it is not. And as it is reported, the appropriate step has been taken by the lawyers to the government of Rivers State, which is to file an appeal. And I won't be surprised if this morning they are also filing a motion to stay the execution of this judgment, which for me will be a key step. And the outcome, the decision, the ruling that will emanate from such an application before the Federal High Court will be instructing whether the Federal High Court will want to look at the balance of convenience, which is to put the people of Rivers State at risk, at harm's way. Which balance of convenience is normally one of the determinant factors whether a stay of execution will be granted or not.
Okay.
Yes, I can hear you.
Let's dial back a bit. I get your point about legality of issues, that once the lawmakers decamped in the first place, that they should have gone. But the court has not taken a decision on that. I also want you to go back to the early 2000s judgment that says, which was in favor of the governor of Lagos, said, when the Supreme Court said expressly that you cannot, just give a unilateral judgment to withhold the allocation to a state. So taking into cognizance there, is it a case of many wrongs trying to make it right, in this case in Rivers as we speak today? Because like you said rightly, the court has not settled the case of the lawmakers at the camp. But also, you are now seeing the court here trying to withhold the funds of the River States. That's one. Two, do you think you have the hands of Mr. Wike written in all of these matters as we speak today? And what will be the future of our judiciary in critical matters like this?
Thank you very much. Let me start from your reference to the decision in the AG Lagos State versus the AG Federation, which is the withholding of the funds of the Lagos State government in 2004 by President Obasanjo. Now, that decision, if you read that decision very carefully, you will see the holding of the court that the president could not, by administrative action or executive action, withhold the funds meant for Lagos State, and that if there was a dispute, the only appropriate forum for contending, for ventilating that dispute, will be the courts as created under Section 6 of the Constitution, particularly Section 6(b). Now, the people who are doing this have studied that judgment very carefully, and because the powers as determined by His Lordship, the CGN, as it then was Mohammed Uwais, that only the court could make that determination. They studied that decision very carefully, and rather than taking an administrative action or an executive action, have decided to approach the court. Whether this is right or wrong is a matter that will be settled by the courts ultimately. However, we should be very mindful. You talked about whether the judiciary, it will augur well for the judiciary. I think it's beyond the judiciary. What we are up against is the entire edifice called Nigeria. We need to be careful and look at our history. And say Fubara is of the People's Democratic Party and opposition party. We are seeing a reenactment of what happened in the Western region, where the action group was in power, the opposition party, and there was a division, there was crisis, perhaps instigated by the party in power, which was the MPC. We saw how it spanned out from 1962, when Awolowo and other leaders of the party were convicted and sentenced. and put in jail. And what eventually triggered all of this was this kind of situation. I think that we need to be careful and very mindful of the fact that what is happening in Rivers State has the capacity and propensity to degenerate this country into something else. I think it's beyond the judiciary. And I think that if the judiciary is mindful of this, of course the judiciary is not expected to embark on their decisions on the basis of media reportage. However, they do not live in isolation. They are part and parcel of the society. I believe that what is happening in Rivers State must be handled in a manner that we do not go the way of what happened between 62, 64, 65, and eventually what led to the coup of January 15, 1966. If we are guided by our history, by the fact that the political class cannot railroad this country into a situation where the entire edifice collapses on everybody, people should be. And the people who are in leadership today were not children as at 1966. They should know. They should know better. But I think that ultimately, I believe that the judiciary is going to do what is right. The decision, if it goes on appeal, we shall see whether the court of the Federal High Court can withhold. Because another angle that must also be considered is whether this is not a dispute between the Rivers State government and the government of the Federation. And if that is the case, will the Federal High Court have original jurisdiction to double into it? Because withholding the allocation of a state cannot just be a matter between individuals. Okay. It is now the agency of the federal government, like the CBN, that is now being made not to release money, and the AGF. Yes. I believe that this, when it is ultimately considered, that the courts will make the right decision, and we are going to see a situation where that decision will ensure that our democracy is protected, not just in Rivers State. The implication of this,
as you're making this,
what is going on in Rivers State is that the people are the ones who will suffer ultimately if you withhold the revenue meant for Rivers State. And I'm glad that the recent decision of the Supreme Court in
So as you're making these points, you know, a number of things are coming to mind. And you made the statement that this is now beyond the judiciary. However, we're in this situation because there was an intermediary who came to attempt to settle these affairs. And that, of course, was the president who brought all parties to the table. And there was a peace resolution that was proposed. And Governor Fubara abided to all of the terms on his side. And he's now saying that he has been ambushed because the other side of the deal are not agreeing and sticking to the terms that had been proposed in that peace settlement. So if the courts are not going to settle this matter, and you're saying they're bigger than the courts, if a political solution which involves the president himself has been unable to resolve this matter, then where do we find resolution for this matter? And can we truly believe that this is truly just between Minister Wike, and Governor Fubara, because it almost seems like there's a bigger play, a bigger power at force who is allowing all of this to continue going. Is it time for the president to step in?
You've seen it for yourself. Now, a lot of Nigerians have been raising concern about how the judicial system is gradually, allegedly degenerating into what it is right now. Just like we heard also that just yesterday or the day before yesterday, the Chief Justice of Nigeria, in person of Justice Kanu, summoned two judges regarding to some conflicting judgments that they gave on one particular matter. Anyway, I really don't like talking about these judicial issues, so I'd like us to jump right into the video that has gained media attention of the OPM